Good day, Crime Talk aficionados. My name is Scott Reich, and this is Crime Talk. And you know what this is? It is the weekly recap of the top stories from July 29th, 2024, all conveniently located in one video. That's right. It's the weekly recap of all the top stories throughout the week, conveniently located in one video. Therefore, I just saved somebody from typing in, "Is this a weekly recap?" ? I hope you enjoy the show. Thanks for watching.
Hi, lawyer.
Next, let's talk about a killer cop. I know we'll give him the presumption of innocence. However, it's not a whodunit, and he, in fact, did kill the person. I'm not sure what he's going to say. I guess the trial is going to be self-defense, but the sheriff deputy who killed the unarmed mom named Sonia Massey in her kitchen after she reported a suspected prowler needed high-stress decision-making classes. All right, this Sean Grayson guy, let's face it, when you hear the end of this guy should never been a deputy sheriff. Now, sheriff's office, the Logan County Sheriff's Office where he was employed when he killed Miss Massey, you need to get your checkbook out. Not just because he probably killed this woman in cold blood, but also because you were stupid enough to hire this guy. All right? Now, Sean Grayson received recommendations from the Logan County Sheriff's Office in Illinois after he failed to slow down when his boss called off a vehicle pursuit. He was driving around about 110 miles an hour and struck a deer just a few years before he shot Miss Massey in her kitchen over a pot of boiling water on July 6th. Now, Deputy Grayson pursued this truck through Lincoln County at a high rate of speed, reaching speeds of between 63 and a 30-mile-an-hour zone. And his boss has said that showed not good decision-making skills. And the report noted that Officer Grayson, Deputy Grayson's supervisors terminated the pursuit, and Grayson ultimately turned off his light. He then continued at a high rate of speed, up to 110 miles an hour, prior to striking the deer. Apparently, Deputy Grayson acknowledged the errors of his ways and said it was just because he had a lack of experience. It would go on to list a series of recommendations, including traffic stop training, report writing training, high-stress decision-making classes, and needs to read, understand, and discuss the issued Logan County Sheriff's Office policy. Now, it's unclear whether Deputy Grayson ever followed through on those recommendations. He resigned from the Logan County Sheriff's Office in April of 2023, and in the next month, he joined the Sheriff's Office in Sangamon County, where he shot Miss Massey in the face. Now, Miss Massey, who had a history of some mental health problems, called the police to her home in Springfield, Illinois in the early hours of July 6th on the report of a prowler. The two Sangamon County Sheriff deputies responded to the call, and after a 30-minute search of the area in which they didn't find any suspect, the two went inside to Massey's home and engaged her in conversation. They then found a pot of boiling water on the stove, which Grayson asked her to shut off and basically threatened to shoot her. The body cam footage shows the young woman ducking and apologizing as the deputy fires 3 times. Now, the autopsy has determined that Miss Massey was shot in the face below the left eye, which caused her skull to fracture and perforated her carotid artery. That caused the brain to bleed before the bullet exited the back of her upper neck. Now, Massey also suffered from minor blunt force injuries to her right leg, according to the coroner. Now, Grayson had since been removed from the force and charged with first-degree murder, aggravated battery with a firearm, and official misconduct in Miss Massey's death. The former deputy who lost his job over the shooting pled not guilty to all charges, and he is currently being held in the jail awaiting trial. Now, he had a kind of a lengthy history of, not being a good guy, all right? First, he was discharged from the Army, which was listed under misconduct, serious offenses. Now, the Army didn't release all the information other than saying that Grayson was discharged, citing Privacy Act type of laws and things like that. I get it. But Grayson worked as a wheeled vehicle mechanic for the Army between May of 2014 and February of 2016, and he left with the rank of Private First Class. That'd be an E2, I believe, in the Army. Not exactly catapulting himself up the ranks there for sure. Anyway, during his time in the military, he was charged with a DUI offense in Illinois back in August of 2015 and another shortly after his discharge in 2016. Records also show that he paid thousands of dollars in fines for an unlawful act that his car was impounded after the 2015 incident. Now, Grayson has also jumped around from various police forces, working for 6 agencies in 4 years. Now, his first police job was at the Pawnee Police Department, where he held a part-time position between August of 2020 and July 2021. And according to the Illinois Law Enforcement Training and Standards Boards, he also worked at the Kincaid Police Department in February through May of 2021, the Virden Police Department in May of 2021 through December of 2021, and those were all part-time positions. Then he held a full-time position with the Auburn Police Department from July of 2021 through May of 2022, and the Logan County Sheriff's Office from May of 2022 to April of 2023, and he started in the Sangamon County in May of 2023. Maybe he just couldn't find a right fit for him. Part-time, usually if it's part-time, they even still want to bring you on full-time if you're good to go. But when you bounce around that many times in a short period of time, you got to wonder if there's a problem there. You really do. Could be completely innocent, just trying to better his advancement opportunities. But when you watch that video, the interaction, something's not right with that guy. I don't know. But why is somebody with 2 DUIs being allowed to be a police officer in the first place, right? Like I said before, public servants, you have a obligation to do it better and cleaner than everybody else since you're going to be enforcing the law. And it's kind of hypocritical of you to not be able to follow the law yourself and then hold everybody to a different standard. That's right. Let the games begin. Yes, the Delphi murder case. Now, this is not being televised. I wish it were. If I had CrimeTalk 1, which I went and checked on today, we could go out there and check this out because this is going to be a circus. That's right. The hearings as it relates to Richard Allen. Now, he is scheduled for hearings the next 3 days. Now, for those who aren't familiar with it, Richard Allen is accused of killing Libby German and Abby Williams in Delphi, Indiana back in 2017. And the hearing is scheduled for 3 days, Tuesday, Wednesday, and Thursday. And it is all taking place in Carroll County Courthouse in Delphi, Indiana. Now, over the next several days, the judge will consider 6 main topics. First, Allen's safekeeping. Should he stay at the Indiana Department of Corrections facility or move to a county jail right before trial so he can assist his attorneys with his defense? Psychologist statements, whether statements from the Indiana Department of Corrections psychologists can be used. Motions to suppress Mr. Allen's statements. Defense wants to suppress what he said while in custody before trial and what he said to Indiana state police officers the day that he was arrested. There's a bunch of discovery issues. Defense wants to compel some discovery from the prosecution and have the prosecution sanctioned for not turning it over already. Now, what both sides can and can't say in front of a jury without specific permission from the judge will be decided. Those are motions in limine, as well as defense requests to dismiss the case. As it relates to safekeeping issues, Richard Allen's defense team is requesting to vacate the safekeeping order, which would move Mr. Allen out of the Indiana Department of Corrections custody. The defense is requesting Allen to be housed in either the Cass County or the Tippecanoe, if I pronounce that correctly. I'm sure I failed miserably. At the county jail. In July of 2023, the judge denied the previous request to vacate the safekeeping order. At that time, though, she wrote, "It is reasonable and necessary to ensure the defendant's safety and to prevent serious bodily injury to himself." As it relates to the psychologist statements, the state is asking the judge to decide before the trial whether certain communications from Allen and the Indiana Department of Corrections psychologists can be admitted. The state said it believes some documented statements fall within an exception to the confidentiality as it relates to the doctor-patient privilege. It cites a portion of a code saying information may be an exception in the following circumstances. 1, trials for homicide when the disclosure relates directly to the fact or immediate circumstances of said homicide. Statements are documented in the report she titled Department of Corrections Behavioral Health Suicide Observations. Now, the defense has two motions to suppress various statements. The first motion to suppress deals with statements Allen reportedly made while in pre-trial custody. The defense wants to eliminate the possibility of prison guards or other inmates testifying about what they reportedly heard Mr. Allen say. The second motion to suppress deals with statements made to the Indiana State Police just before he was arrested. Back on October 26 of 2022, Allen and his wife went to the police station in West Lafayette to pick up a vehicle that was seized earlier that month. When they got to the station, Allen had a conversation with the state trooper, Officer Jerry Holloman. The defense wants the contents of that conversation kept out of evidence and not submitted to the jury. Prosecutors object to both motions to suppress the statements, stating that they're legally permitted. They're admissions by a party opponent in this particular case. Remember when we always say anything you say can and will be used against you? People think it's just statements to the police. It's not. It's anything that you say to anyone that is relevant to the case at hand. It's an admission by a party opponent, ladies and gentlemen. That's not hearsay. As it relates to the motion to compel, the defense filed a motion to try and compel the state to turn over discovery and to do so within a timely manner. They are also asking for sanctions against the state prosecutors. Now, the defense wants the prosecution to provide a written explanation of what the defense says is a delay in providing evidence and why the prosecutor sent an email filled with false statements and misleading the defense. Now, much of the motion's detailed discovery, the defense claims, was turned over later than it should have been, and often in a way that made it difficult to determine what is what in the discovery. The defense wants 4 sanctions: for the court to tell the jurors the prosecution violated rules with the delay in turning over exculpatory evidence, permit defense to play any video that was produced late without state objection, prevent the state from rebutting evidence former Rushville Police Chief Todd Click provided on May 1st of 2023, and prevent the prosecution from using any data or information from Liberty German's phone in evidentiary presentations. There you go. Interesting sanctions indeed. You notice they're not asking for the case to be dismissed based upon those sanctions, because that is an extreme remedy that the judge would not likely grant. They're getting a little creative. Obviously, they don't want any data from Liberty German's phone. Interesting sanction indeed. I think it will be denied. The remedy for any sanction is normally a continuance, which the defense has had to ask for. I don't see Judge Francis C. Gull imposing any sort of sanction against the prosecution in this particular case. Well, primarily because she hates the defense attorneys. And I'm not understating that. She hates the defense attorneys. Next, as it relates to motions in limine, the state wants the court to limit what the defense can mention in front of the jurors without prior approval from the judge. There are several pages of items. They include personal attacks on the prosecutors, which I'm going to agree, you shouldn't attack the prosecutors. I mean, you can say, maybe they were delayed, or who was at that meeting, or whose decision was it to delay the production of that evidence. You can answer those questions or ask those questions to the witness, but you should never personally attack the prosecutors in court. Any attempt to introduce evidence of third-party motive that is not relevant or would unfairly prejudice jurors. That goes to the whole issue of the cult, the Odin cult, and other people involved, and could it have been done? But I think that is a defense theory of the case, and prosecutors shouldn't be allowed to ask the court to prevent them from presenting their theory of the case. Like I said, so the prosecutors don't want any mention of Odinism, ritualistic killings, names of others the defense might claim are connected to the killing. That goes to alternate suspect. Normally you have to be able to establish that the alternate suspect was there at the time, could have committed these crimes, and has a pattern of doing those. That would be very tough in this particular situation. Anyway, like I said, the case of Ashley Benefield. We brought you the case live last night at 10:30 Eastern time, because that's what we do here at Crime Talk. Well, that's what Frank does. We just happened to be here because we did our Tuesday night live show, but then we did our Patreon show, and then we had to jump over to the Ashley Benefield. First, the jury was hung Then they came back and said, no, we want to continue to deliberate. And they came back guilty. That's right. So the former ballerina accused of fatally shooting her wealthy husband appeared a little unemotional when she was found guilty of manslaughter in a Florida courtroom, like I said last night, about 10:30 p.m. Eastern time. Now, Ashley Benefield stood trial for the second-degree murder, for charges of second-degree murder, of her husband, Doug Benefield, in the case known as the Black Swan murder. And the trial received, obviously, a lot of attention. We brought it to you. Did I mention that we brought it to you live at 10:30 last night when the jury came back? And her bond was revoked, and she was sent to jail. Anyway, after nearly 7 hours of deliberations, the jury found her guilty of discharging the firearm that killed her estranged husband in her mother's Lakewood Ranch home back on September 27th of 2022. In self-defense, despite prosecution arguing that she had planned his murder. Now, Doug Benefield's daughter, Eva, was in tears as the jury read its verdict. The ex-ballerina has stuck to her claim that her ex-husband attacked her the night that he showed up to her house unannounced. Anyway, the couple met at a political event back in August of 2016. Now, Ashley was a trained ballerina, and she was 24 at the time, and Douglas Benefield, who had worked in the defense and private equity sector, was 54 years old. Anyway, they tied the knot after only 13 days of courting each other, and guess what? She became pregnant with their first child soon after a failed business venture. All within a year of being married, they apparently reversed Doug's vasectomy, got pregnant, started a ballet company, and it went defunct. Their relationship began to deteriorate during the time that Ashley was pregnant, and then she ultimately left their home in South Carolina and moved to Florida, where she was staying with her mother. Now, they continued this long-distance relationship for a little bit, and they tried to keep the communication going, but it didn't work out. Anyway, she began making complaints to local law enforcement about being the victim of non-physical domestic violence soon after she moved to Florida. Now, her defense attorney argued that she was trapped in an abusive relationship, claiming that Doug was a manipulative, controlling, abusive man whom she killed in self-defense in fear for her and their young daughter. On the day of the shooting, when Douglas Benefield was there to help Ashley pack up, her attorneys claimed that the visit turned violent. Now, the defense argued that he was angry when he arrived at the house because he knew their relationship was ending, and the ex-ballerina alleged Doug threatened and then shoved her during the visit. The estranged husband then allegedly slapped her in the face, and she fled into the bedroom, grabbed her gun for safety, according to her attorney and her testimony. And when Doug allegedly followed her into the room, where she yelled at him to stop before she fatally shot him. She testified, quote, "I thought he was going to kill me." However, investigators later found no sign that she had been physically abused or that she was acting in self-defense, and that she had fired 4 rounds from the .45 caliber handgun, hitting her ex-husband, twice. Anyway, detectives said that based upon where Doug was hit, it doesn't appear as though he was facing Ashley when she began shooting. Now, prosecutors told the jury during Tuesday's afternoon closing arguments that to accept Ashley's self-defense claim, they would have to find her actions reasonable and necessary. The prosecution argued that Ms. Benefield killed her former partner because she wanted sole custody of their daughter, and the defendant used domestic violence allegations to make progress on her goal. She wanted sole custody of her child, and she was willing to do it at all costs, the prosecutor argued. Well, after the verdict was announced, the judge who was overseeing the case, who actually did a very good job. As you can see, most murder cases don't take weeks. This could have been done Friday had the defense had their act together with their expert. Swear to God, that's how fast this case could have been done. Anyway, the judge revoked her bond that she had been released upon, and she will remain there in custody awaiting sentencing. Now, the prosecutor last night said, hey, revoke her bond. Circumstances have changed. She's now been convicted, which makes her now presumptively a flight risk. And the prosecutors last night said that she was facing up to 30 years for a maximum sentence. I've seen different reports that say it's 15. We'll try to clarify that by tomorrow. Anyway, did I mention CrimeTalk brought it to you live and we were here to take the verdict. Yeah, Frank and I here. The name you can trust, ladies and gentlemen, the name you can trust. Crime Talk. Next on the docket, the Young Thug trial. How many violations of the Georgia Code of Judicial Conduct does it take to get a mistrial with prejudice? Well, we're going to have to wait and see, but I think we're getting close. All right. We have talked about this. We here at Crime Talk, I think we need to do it. I think we need to do a wall of shame of some of the worst judges ever. And the first one, we'd have to go way back in time for Judge Alito, who did the O.J. Simpson trial. And we've got lots of bad judges to add to that wall of shame. And the judge in the Young Thug trial, yeah, he should go too. What a complete fiasco. So, as you know, the Young Thug trial is now facing yet another ethical test due to another round of alleged judicial and prosecutorial misconduct in the racketeering prosecution against Young Thug, a.k.a. Jeffrey Young Williams. And, of course, a bunch of other cohorts that he hangs out with. They're all in trial. Yesterday, there are new allegations of a second secret ex parte meeting between since-recused Fulton County Superior Court Judge Earl D. Glanville and two prosecutors in charge of the long-running case, and they were revealed in a supplemental defense motion that was filed yesterday. Now, these new allegations come some 2 weeks after Glanville was removed from the case over another secret ex parte meeting between himself and the deputy district attorney handling the case. That would be Adrian Love and Simone Hilton. Now, the judge's controversial time at the helm of the nearly 2-year-long proceeding was marked by frequent allegations that the court was acting like a prosecution team member, during which Mr. Glanville was accused of displaying a decided animus for the defense and the defense attorneys. Whew, haven't we all been there? And that's a problem, Judge. If you want to, be a prosecutor again, come have a seat over here, but just get off the bench. Start calling balls and strikes. Anyway, the secret meeting that forms the basis of this new allegation was actually the first such secret meeting, and it occurred back on June 7th, according to the motion filed by the defense. The secret meeting that previously also blew up the trajectory of the case occurred on June 10th. Now, in each instant, the secret meeting concerned the testimony of the state's star witness, a guy by the name of Kenneth Lil Woody, Mr. Copeland, Kenneth Lil Woody Copeland, who reluctantly took the stand only after he was held in contempt and threatened with substantial jail time by both the state and the court. Well, there's a new transcript, and it shows that Love and Hilton, the prosecutors, discussed Copeland's former attorney, a guy by the name of John Melnick, in a disparaging fashion after Copeland pleaded the Fifth Amendment and was thrown in jail. Well, Judge Glanville responds by telling the prosecutors he understands their concerns, but he's limited to his remedies that he has before him, before pivoting and invoking into the specter of outside agitators somehow wreaking havoc on this case. Well, the filings characterize the outside agitators' claim as Glanville making outrageous allegations against the members of the defense team. The filing goes on to say that such outrageous conversations is evidence that the trial is being conducted unfairly. It is not a fair trial in an ex parte meeting, Glanville, Love, and Hilton gossip, as they gossip over nearly 13 pages of transcripts about attorneys Shart, Melnick, and Steele. It's not a fair trial when it is an ex parte meeting, Glanville, Love, and Hilton assassinate the characters of the attorneys, saying they're not acting in the best interest of their clients. The filings repeatedly accuse the court of bias permeating the trial in other ways, including the allegations that one of the prosecutors lied to the court about an email she received from Copeland's former attorney. In sum, the defense argues the bias has been overwhelming to the point that the case should be dismissed with prejudice. They state, how many violations of the Georgia Code of Judicial Conduct does it take to get a mistrial with prejudice? The defense motion continues. This case is like an old house that the present honorable judge is tasked with renovating, but every time a piece of pasted up wallpaper is removed, more rot is found hidden underneath. The Herculean effort of the present court can fix the due process violations of the last judge. This house must be torn down. A mistrial should be declared and the retrial barred due to prosecutorial and judicial misconduct that goaded Kendrick into the present motion. I'm going to agree. First, why was the judge having ex parte communications with the prosecutors and the defense not present? This Judge Glanville should be removed. I mean, this is like Judge 101 type of information that he should know. And he did it because he thought he could get away with it because he's the chief judge. Who's going to question him, right? And then we find out it wasn't once, but it was twice. The judge didn't report it. And more importantly, the prosecutors haven't admitted it. This is getting into a situation where the prosecutors should have at minimum said there was a conversation, reported that to the defense so that they could put it on the record and try to explain why they didn't do it. They didn't do it. I hate to throw the E word around, but I'm very concerned as it relates to the prosecutor's conduct in this particular case. And if they get it dismissed, kind of like the Alec Baldwin case for doing shady stuff, so be it. And guess who do you have to blame? Not the defense, but the prosecutor for playing fast and loose with the rules. And in this case, it seems like the court is somewhat complicit in what is taking place. I say dismiss the case. That's my position. We'll see what happens. I know. We'll just have to wait and see what happens. I know people say that. Oh my gosh. But it's true. Next on the docket, Justin Timberlake's attorney gets admonished at the hearing, the arraignment for Justin Timberlake. This morning, Justin Timberlake had to appear via WebEx in New York for his court appearance as it relates to the DUI charges that he is potentially facing. Now, he had to appear virtually in Sag Harbor while he was in Antwerp, Belgium on his tour. And he was back in court for a rearraignment as it relates to the June 18th incident where he was charged with driving while impaired. Now, the judge advised Mr. Timberlake that his license to drive has been suspended in the state of New York because of his refusal to take a breath test at police headquarters after he was arrested. That revocation should be for at least 60 days. Now, the attorney for Mr. Timberlake, Mr. Edward Burke, Jr., made an effort to dismiss the case, citing errors in the original charging documents for Timberlake's arrest. However, the judge said, hey, we'll fix that problem because the prosecution fixed their paperwork error. So let's get Mr. Timberlake on the TV and let's rearraign him as quickly as possible. And guess what? Mr. Burke withdrew his motion to dismiss the case for the officer's decision to have a temporary officer sign the summons and complaint versus a full-time duty police officer do it. So the police said, fine, we'll fix your paperwork. And once that was done, Mr. Burke had to go with his tail between his legs and withdrew his motion to dismiss the case. Well, the judge also admonished Mr. Burke over his comments at the previous court appearance, calling them very irresponsible. Mr. Burke had spoken to media outside the courthouse on July 26, insisting that his client, Mr. Timberlake, hadn't been intoxicated on the night of his arrest and that he was moving to have the case dismissed because... Anyway, the judge said Mr. Burke's statement come off as an attempt to poison the case before it's even begun and threatening the attorney with a gag order if he continues to make such outrageous comments. He also warned Mr. Timberlake that he may be ordered to appear in court in person for future hearings in the case, particularly if his attorney acts up. Another hearing is now scheduled for August 9th, which Mr. Timberlake does not need to attend. Now, for those who are not familiar with this, Mr. Timberlake, that's right, Justin Timberlake, that famous guy, and I like Justin Timberlake. Anyway, Mr. Timberlake was arrested for drunk driving in the early morning hours of June 18th after he was pulled over in Sag Harbor for allegedly running a stop sign and veering out of the lane while driving his BMW. So you know he can't be all that bad. Anyway, he refused to take a test, charged with DWI. Yeah, we had the perp walk of shame for Mr. Timberlake coming out in handcuffs. He's obviously entered a plea of not guilty. We'll give him the presumption of innocence. And more than likely, this case will be pled down to something better than probably you or I would ever get for ourselves. Just throwing that out there.